Hi everyone, just give us a few moments while everyone joins today's webinar. I think most people are in. There's some people still connecting to audio and we're going live to Facebook. Just give me one more moment.
Did you get connected? It keeps freezing.
Oh, right.
I don't think we need to share videos.
Greg, there's some people joining, but I'll just keep lining them in as they come in.
All right, well, let's start for today's webinar. So welcome to the next installment of the Calm is Contagious webinar. And so this is session number 5. Today we're dealing with the commercial leasing code requirements. Just some housekeeping for the webinar. Just due to bandwidth, make sure you can hear everything that's been said. If you'd like to mute your microphone and turn off your video, during the webinar, there will be an opportunity to ask questions either by unmuting yourself and speaking, or during the actual webinar, if you just want to put a question in the chat box, which is down the bottom. If you click on chat, there's the ability there to ask questions or make comments, and we'll endeavour to answer those questions either along the way or towards the end. If there are some questions that we're unable to answer, or we need some further information, we run out of time, for instance, we can take that question offline and come back to you and get in touch in the future to hopefully give you that answer. So my name is Craig Mason and I'm a director here at SMS Law. And I have with me the other two gentlemen that you could see, Mr. Jeremy Stretton from SMS Law, who's also a director, and Ashley Reese from Ray White Commercial Northern Corridor Group. So he is a commercial real estate agent. And as I said, today we want to talk about the commercial leasing code requirements, and this is about the support for tenants and for landlords. So today's what we're going to go through is relevant for investors, landlords, tenants. So it's going to have a broad variety of information to suit all three of those. So it's not just for one of those. So there are sweeping changes that we'll go through. It's pretty important. It's something that's been we've been waiting for, I guess, for some time for these changes to come through. And now the Queensland government passed and put the code requirements through last week. So I think we'll kick in. Jeremy, you're going to start things off for today's webinar.
Thanks, Craig. Yeah, so I just wanted to start by just giving an overview of what I'm going to talk about today. So Ash and I are going to present, and we're going to talk about, really there's 6 parts to this, these regulations that were passed by the Queensland government. We're going to talk about the request, sharing sufficient information and offer, negotiating the agreement itself, and then just briefly on mediation. So just on that, there is the ability, if people don't come to an agreement under the regulations, for mediation. I'll talk a bit about that and a bit about the process later. And yeah, so as always, please pay attention. As Craig said, feel free to ask questions. You can ask them as we're going, or you can put them in there and we'll get into it at the end. So I'll start off with part 1, which is the request. So the regulations talk about affected leases. And what is an affected lease? An affected lease is a lease for either a retail shop or another type of commercial tenancy where there's a turnover for the business of less than 50 million in either the 2018-19 financial year or the 2019-20 financial year. The tenant has to be eligible for, but not necessarily receiving, the JobKeeper payment. So if you haven't been on top of what JobKeeper is, I'm sure everyone on this call is, but JobKeeper is the government, the federal government initiative to keep people employed through the pandemic. And you can have a look at our previous Calm is Contagious webinars for discussions about that. So got to be that. And you've also got to have a current lease, and a current lease as at the 28th of May 2020. It actually goes back and applies to all leases that were in place back at the end of March 2020 and goes through March and April and into May. So they're the first things that have to be applied for, that you have to be an eligible affected lease. And we've seen quite a few people who thought that they'd be affected, thought they could use these criteria and these regulations, but they're not actually an affected lease because they don't fall within one of those three categories. So that's the first thing. Now, the request itself, the rules are very explicit that one of the parties, either the landlord or the tenant, has to actually request that there be some sort of negotiation about the lease and the lease terms. And so there's got to be a formal request come in from either the landlord or tenant. I think, practically speaking, the request would come from the tenant because the tenant is the one who's mostly affected on a day-to-day basis by the JobKeeper and the COVID-19 situation. So the request should come from the tenant in most situations. However, if a landlord is concerned, if they're not hearing from the tenant, then they can actually initiate this as well by making the request and say that they need to be dealt with, or this needs to be dealt with as part of the regulations that have been introduced. So that's the request, pretty straightforward. And the second part is the sharing of sufficient information. And I think this is probably where there's the most real opportunity for disagreement. And there's also probably the least clarity in these rules about what is sufficient information. And you can kind of appreciate why there's not the crystal clear clarity over what people can provide, because really it's what's fair and reasonable in the circumstances. And the regulations and the national code all talk about acting in good faith, and both parties acting in good faith. So whether you're a tenant or a landlord, you're acting in good faith to make sure that you get the best results. So I think that when a tenant is providing this sufficient information, that they should also be making the request of the landlord to enter into a negotiation under these regulations. So I've put together, and we can provide, if you'd like, these afterwards. In fact, we will provide them when we email out after this, forms with actually set out the sufficient information that a tenant and a landlord can require. But the regulations talk about a statement explaining why the tenant and the tenancy has been affected by the COVID-19 situation. So for, say, a restaurant or a premises that has been completely shut down, like a gym, that could be quite obvious. It could be that under the health regulations, our premises were shut down and we were no longer able to operate a business. If you're a different type of business, say a professional services business, whose rent has been affected whose income has been affected and who is applying for a reduction in rent, it might be something to do with the clients and the people that you act for being affected, and that being a reason that you're needing to make this application. You also need to show that you're eligible for JobKeeper. So there's a few different ways that you can do that. One is there's certificates that you can get from the federal government to say that you're eligible. Two, if you haven't applied for it, then you can provide your financial information to show how you've been affected. Now, you need to provide some sort of financial information anyway, because the way that this works is that, and we'll talk about it in a minute, is that basically there's a reduction in the rent that landlords can recoup from tenants during the period, which is the 1st of April through to the 30th of September. There's a reduction based on a reduction in rent and a deferral of rent, and how that's actually to be applied is dependent on the circumstances. And but you've got to show that you actually have had a reduction in rent, in income, to be able to be entitled to that reduction in rent. So you have to provide some sort of financial information, whether that be a BAS, a business activity statement, tax returns. They keep it nice and broad. Could even be management accounts that show that the rent or the income has decreased, and that will allow the parties to then get into the next few stages of that negotiation. So, which Ash will talk about. You could provide other information about if you're concerned that a tenant might not be a small business. So I said earlier that an eligible business has to be under 50 million. That's very easy to provide evidence of that, tax returns from the last year. But if you're concerned about that, then you can dive a little bit deeper. They do also talk about what you're not allowed to ask for. So from a landlord's perspective, and I think these are important things to understand what as a tenant, if you're a tenant, what you can't be asked for, and if you're a landlord, what you can't ask for. So things like future cash flow projections, you're not allowed to ask for those. Balance sheets, profit and loss, and year-to-date financials, landlords can't request that. Tenants' bank balances, can't request that either. Trust account information. So if you're a business like a law firm or a real estate agency that operates a trust account, the landlord can't ask for information about that account. You can't ask for evidence of refusal or ineligibility for other government programs. There's other government incentives that are being provided, other government loans available. You can't be asked to provide that information. You can't ask for that financial information to be verified, examined, assured, audited, or provided by a third party by an accountant and have it actually audited. Can't do that. There's no ability to do that in the rules, and you can't ask for onerous documentation to be provided. So what that is usually something that has been will require someone to go away and actually prepare it for a fee. So landlords can't request for documents to be prepared that aren't in the normal accounting bookkeeping space because they've been explicitly excluded from that. The other thing too with all this information is that there are some pretty hefty confidentiality clauses. So tenants can feel safe in providing the information that they need to provide, and that landlords and agents and lawyers and accountants, whoever gets involved in the process, can't disclose that information to any party. So sharing sufficient information is, as I said earlier, where I think one of the biggest dispute points could come here. What is actually sufficient information? And the government has done a fairly good effort of showing what can be provided, what can't be asked for. So, as I said, that's an overview of what you can ask for, what you can't ask for. And I'll hand it over to Ash now to talk about the offer and negotiation, and probably talk about a bit about that as well, mate, if you want to.
Yeah. So this is the part where you come up with a plan that no one's happy with. So it tends to be the sign of a good thing. And it's probably just jumping back a little bit. Reading through this, it's been reassuring, and for those that have seen the last couple that we've done, that we weren't far off the mark on any of the points that we covered. So the general vibe still remains the same of you sort it out or we will from the government. The state's taken that same approach. Coming into step 3, you've touched on it in your notes too, Jeremy, that steps 1, 2, and 3 can all be kind of completed in one fell swoop by the tenant if they prefer. So they can request assistance, show the impact, and then present a solution. So step 3 being the offer is by the legislation that the offer is to come back from the owner once the tenant has submitted the requisite information. A few teeth that have come into the legislation. There's now a timeline, 30 days from receipt of information is how long the landlord has to reply, and they must make a response in accordance with the regulations. So the crux of it being the rent impact is they've adopted the same as the national code, being a rent reduction of at least 50% of the revenue drop, and so it's 50% rent reduction, 50% abatement. Deferral. So yeah, 50 dropped off, 50 deferred of whatever the impact is shown through the JobKeeper percentage that the tenant can show. Now, if the deferral goes over the end of the lease can be extended as well. So that's going to create some interesting negotiations for owners and tenants as well, where there's a period of between 2 and 3 years from the 1st of October when that deferred rent can be recouped. So yeah, that's especially on shorter term tenants. That's going to create some interesting situations for us to work through. Getting into the negotiation is still in that vein of in good faith, and that they're actually, the commission is starting to put a few guidelines together on exactly what that means, but it's pretty as we read right through it, it's pretty common sense. You know, the acting in good faith is tenants being transparent in the information they provide, giving the ATO acknowledgement of JobKeeper. That's the main step one. If you're not willing to give that, then that's a tricky one for any owner to overcome. And then from the owner side, responding in time, taking into account the impact that each element is going to have on the business, and from both sides also the tenant factoring in what the impact is going to be on the owner and their specific financial situation as well. So it's a large document that still, when it comes to, you know, my part in it and the conversations that we're having, it comes down to that good faith, transparent communication between the owners and the tenants. And so this bit hasn't changed too much from the code. The information that's required, they put some specifics around that. And probably, Jeremy, the bit you'll go back into on the legal front is, once we either have the handshake or we don't, what's the next step? So getting into the actual agreement and documentation.
Yeah, thanks, Ash. So yeah, the agreement, I mean, it's, as with anything, it's important that you document these things. And the regulations have been pretty specific that they want everyone to document it. So yeah, we know that, you know, it's been 2 months since this was announced. A lot of handshakes have been done. So now we just need to monitor what agreements were made and make sure that they fit with the code, and then document the agreements. And for people who haven't made agreements, well, then we need to get into that as well. So documenting the agreement is really, really important. It should be a fairly straightforward agreement. The complicating thing, as Ash said before, was if there needs to be some sort of extension to the lease to factor in the 2-year time and payment time frame, then that will need to be properly documented in the agreement as well. So you know, making sure that that's done properly is really, really important. You know, and making sure that, you know, it's at least looked at by a lawyer, I think is really, really crucial, because you're actually documenting a fairly significant change to the lease. Then the last thing, you know, if you can't reach an agreement, the regulations do provide a formal mediation process. Our hope is that at least no one on this call, hopefully, fingers crossed, and most of the people that we deal with won't need to go to the mediation process. However, it should be noted that it is there. It's there, and it's designed to resolve any disputes. And they've actually said, which is quite rare in this kind of legislation, that if you don't comply with some of the good faith provisions, that you'll actually be looked at quite unfavourably in mediation. And if you don't come to an agreement in mediation, that you would also go to a court hearing, you'll be looked at quite unfavourably there. So yeah, I know that there's a lot of emotion. There's a lot of people who have been hurt on both sides, both tenants and landlords, who have been hurt financially because of what's going on and mentally. Everyone needs to take a step back, make sure that they're acting reasonably as much as they can, because if you don't, then that's when it's going to come back and backfire on you. As I said, there is the facility to go and get the mediation. It's quite a streamlined process. There's an online form, a mediator is appointed, the actual small business commissioner pays for the mediation. But at the end of the day, if you don't come to a resolution yourself, you're putting it in the hands of someone else, and you might end up getting an unfavourable result. So we'd encourage everyone to mediate as much as possible. So that's it on the 6 steps. Ash, did you want to talk about some of the restrictions that are as part of this regulations?
Yeah, so the main ones to cover off on are the termination for non-payment of rent and outgoings remains in place. So that's been adopted. So the landlord must reduce rent in proportion to lost turnover in that 50-50 breakdown. They can't increase rent during the time. So the time period being through till September 30. So even if there's standard market reviews, CPIs, fixed reviews, they can't be implemented or accrued. So they can come into play after that time, but as it sits through this period, there's no rent increases. Can't penalise the tenant for reduced trading hours or not opening, and there's no access for owners to bank guarantees or security deposits due to unpaid rent.
Cool. Yeah. So there's quite a few restrictions. Whether or not you agree with them or not, that's what's being put in place. That's what's being legislated. So we need to comply with those restrictions. So Ash, I'll hand over to you in a minute if you want to talk a bit about the market. Just for any of the agents that are on the call, we've put together a bit of a resource for agents to be able to run through this process, and including some precedent amendment documents. If you'd like to get that, please just message us in the chat. You can either just put it in the chat or send me a private message, and we'll make sure that it gets out there. In the meantime, people want to ask questions, and Craig, do you want to start off with that?
Yep. All right. There's a question here from Paul. Do the regulations set out what information a tenant cannot be asked to provide, or is that set out somewhere else?
So I'll fill that one. So the regulations don't set out the information that can't be asked to provide. What it is there's a page. I might just turn the slides off. Stop sharing screen so people a bit easier there. So the regulations don't specifically say you can't ask for these things. The Queensland government, with the page for the Office of Small Business Commissioner, have set out what they see as fair and reasonable things that tenants and landlords can ask for. So, whilst it's not legislated, it's what they consider to be reasonable in the circumstances. So that's where you provide it, because they are really, really, really clear about what can and can't be provided. Does that answer your question, Paul? Feel free to unmute yourself if you like, if you want to ask anything clarifying on that. Great, thanks, Paul.
Bill's just asked whether or not we can email the regulations.
Yep.
We can do that, definitely.
Absolutely. We'll add that to we'll send an email out after this with a copy of the video and everything, and we'll include the regulations there as well.
Yep. There's a question from Jeff about the tenants obtaining the JobKeeper certificate to supply to landlords. I think my understanding is you can get that from the ATO when you've applied for it. Yes. A certificate to say you've passed the test or whatever it might be.
Yeah, there's an online test that you fill out, and then they give you a certification to say that you're entitled to JobKeeper. Obviously, that's open for manipulation by people. However, the ATO has been quite clear that if you do the wrong thing, then they're going to come out on you like a ton of bricks. So, whilst it might be easy to get it, you want to do the right thing and not get it in bad circumstances.
The important distinction is that you just have to be eligible for it anyway.
That's right.
You don't necessarily need to be receiving it. So I think that's a bit of an area that might come up. And Jeremy, what about with the agreement? Is there any mention of legal costs and any other costs associated with it, and who's paying for that, or does it go back to the lease? Or
yeah, good question, Craig. And yeah, there's no clarification as to whether costs can be paid. Charged to tenants or landlord, or whether each party is to bear their own costs. So it would come down to the lease, or if it's a retail shop, the Retail Shop Leases Act. Craig, I also just received a private question about breaches that are outside the COVID-19 arena. So if there's a breach of a lease that has nothing to do with COVID-19, they're not an affected tenant, or it was something that was actually before the 29th of March, that doesn't stop landlords from going after those tenants for those breaches. So pre-existing breaches can be attacked in that vein.
Yeah, absolutely. There's a question here about the land tax relief. So can the landlord use any land tax relief to offset any rent waiver provided to the tenant in a net lease? The code appears to be unclear. So we've spoken about the land tax relief measures in the previous webinar, and from that, my understanding, guys, is that if a landlord does get any land tax relief, then that's to be part of what's passed on to the tenant. I don't know if that's mentioned in the code, but Ash, have you, from your landlord clients, what's the general vibe about the land tax relief, if any?
Yeah, that's my understanding, is that it's any relief you're getting on outgoings is just a direct pass on to the tenant, not to be offset against any of the waiver. So it's a hand in, hand out straight to the tenant.
Yeah, and are many landlords taking up that relief that you've seen?
Where it's available, yep.
Yeah, cool.
So it's keeping the property managers on their toes with the calculations. But it's it is being passed on. Yeah. So.
All right, excellent. Just a question here from property manager. If a tenant is not trading, we are in the tourism village industry. Is the owner expected to forego 50% rent, defer 50%? Currently, some shops only opening for a few hours Saturday/Sunday. So I don't believe it's forego 50% and defer 50%. It's up to 50% in total for both of those, is it not?
If there's zero trading, then it's it's my understanding is it's full it's full 50-50. So we're deferring half, and as it sits right now, there's zero income. So
all right. So the answer to that question would be yes, forego 50% rent, forego and defer 50%.
And that's deferred till the 1st of October.
1st of October.
When this occurs. And that gets added on to the rent at that stage. I've received a few just other messages privately, Craig.
From Bluestream? I got one here.
No. From Ruth. Hi, Ruth. So just confirming that if negotiations have started and extend past 30 days, however discussions are happening, will the landlord be in breach of the 30 days rule? I would say not. No, it's 30 days for the offer, isn't it, Ash?
Yep, correct. Yeah.
Cool. And Ruth also talked about the 2 to 3 years, or so the repayment is a minimum. So the deferred rent has to be amortized over a minimum of 2 years and no more than 3 years. Is the answer to that. And Craig, do you want to ask the other question that you've received?
Yeah, I've got two more here. Bluestream. I missed the first 10 minutes of the meeting. Okay, we will be sending around the recording, so check that out. Just the question is, are these regulations now standard moving forward, or are they temporary due to the lockdown and China virus?
Definitely temporary. So they're definitely only until the 30th of September. So these will not apply after that unless there's another round of the COVID-19 situation. That might change it, but at the moment it's to end at the 30th of September and only to apply from the 1st of April to the 30th of September.
All right.
I've also been asked if we need to close the doors permanently due to the business not being viable as customers are not returning. Are you able to terminate your lease? No. There's no ability to terminate leases in this code. It is only the deferral of rent that you can do. There may be other avenues that you can take, and I'd be happy to have a chat to you about that. We can review leases and see what other terms are there. I won't say that person's name for confidentiality reasons, but if you do have that problem, come and talk to us and we'll see what we can figure out there.
Cool. All right, there's a few more here. If I ask for January, May 2019 and the same months for 2020, but the tenant has not provided this, I've stated that I can and will provide 50% rent referral either way. Is the information I asked for okay? Is the first question. And then should I insist on the rent deferral, or is the no response a potential indication the request from the tenant not in good faith? So the first part of the question is they've asked for January, May financials, presumably, and then the same for the same period in 2020. Is that okay in relation to the information you can request as a landlord?
My view is that is okay. I think as a minimum, it should be March to May. If they're not providing January, February, that's hard to know for sure, because the argument would be that there was nothing affecting the lease at that time, although a lot of industries were starting to be affected. So I think it does depend on the circumstances, but I would have thought that if they're not providing at least March, April, May, then that's not acting in good faith. What's your view on that, Ash?
Yeah, I'd agree. Yeah.
I think as well with that, JobKeeper's January to March, wasn't it, 2019? And then January to March 2020. So,
well, that's one of the tests. That's the first test, and yes, that could very well be seen as reasonable to do it that way.
Yeah, exactly. And then the second part of the question was, should I insist on the rent deferral, or is the no response a potential indication the request from the tenant is not in good faith?
It's definitely an indication that it's not in good faith, and if they won't provide that information, then it may be that you have to go to the mediation to require them to provide that information. Maybe pointing out their obligations under the regulations would be a good first step to see whether or not and maybe providing them with the regulations might be a good first step to get them to see whether they'll comply and be reasonable.
Yes. And just a follow up to that, the tenant has said they don't want to go into arrears, so they will pay their 50%, but want me to forego my portion of rent reduction. I would think they should go into arrears in good faith in the same proportion I defer the rent, just to help their business. Is this fair? It's potentially a question we might need to get a bit more information on, that we can come back to you, Chip.
Not a problem.
Yeah.
That'd be great. Thank you.
It's probably a little bit too specific for us to answer now. Yeah.
Yeah.
Okay.
All right.
Yeah.
So Chip
I'll
will
follow
plug
up.
that one.
Thank you.
But it sounds like you're on the right track, and you're doing what you can. So, just another question here: can parties agree to repay deferred rent earlier than the 2 years?
Yes. There's nothing precluding them from doing that if the parties agree to that. Yes, they can. If the tenant would just have to make sure that they're going to believe that they could pay that.
Excellent. All right.
So Craig, I might just say that there's nothing that stops you from agreeing to something outside the code so long as it's reasonable. It's just that if it's seen to be abuse of your position, a position of power, or circumstances change in the future, then that could cause problems down the track.
Yep. All right, just scrolling through, we've got another question here. Is the 50% waiver a minimum? As in, would tenants be within their rights, especially if fully shut down, to negotiate terms better than the 50% waiver?
Ash, you want to answer that?
I'll jump on that, yeah, because it comes back to yes, you're definitely in your right to ask for that, Nathan, because there's some wording in there. The landlord has to show consideration that the extent to which failure to reduce the rent will affect the lessee's ability to comply with the lease. So this is a pretty clear situation. If you're completely shut down and have been the whole time, zero income and costs, there's going to be a transparent case there that that's a really hard situation for tenant and owner. So but there's absolutely scope to negotiate a larger waiver, and so the ruling is no less than 50% waiver. So that's the bare minimum. But yeah, it depends on how on the owner and the case that's put forward as well. Yeah.
Right, there's an interesting question here that might require some more thought and research, guys, but I'll read it out and see if you can answer it. If a new owner of a property, or if a new owner is purchasing a property during this period, what is the requirement of the current owners and new owners?
So this is a little bit up in the air. There's nothing in the regulations that deals with assignment of lease. And it's an interesting question. It's been flagged by a few of the regulatory bodies like the Law Society and the REIQ, I know, as a question. I think that if an agreement is done by a current landlord and then the property is sold, then the new landlord would be bound by the agreement so long as they could be shown to be aware of that agreement. And if they weren't aware of it, then the seller would be engaged in misleading and deceptive conduct, because that's clearly something that would affect a buyer's thought process in buying the property. So I think that if a property is sold, then it would apply, and you'd have to be very careful to disclose all of the information surrounding the reduction in rent that's been agreed, because it's a material fact about the property that a buyer would be concerned about. And the same can be said too. Another question. When I read that question before, a question that came up for me with some of the other deals that we've been talking about has been, what about a lease that's entered into since the 1st of April? And the regulations don't deal with that again. So, if a property is affected by the COVID-19 shutdown after the 1st of April and after a lease has been entered into, then arguably it still applies to those properties as well. And so that's something to bear in mind if you're a landlord. And from what we can see, there's no way to expressly exclude that other than an agreement by parties.
I'll just jump in on that as well with a couple of real life examples we've been going through with sales that either went to contract before this or have gone to contract during. There's been quite a few good faith negotiations between buyers and sellers to offset the impact, retention in trust, rental guarantee to offset the difference. There's ways around it that have looked like big insurmountables, but pretty quickly when we drill into the true impact on both sides, after September 30th, it's going to be an unknown. The risk is going to come on to the buyers, but there's ways of mitigating that impact between buyer, seller, and tenant, between kind of tri-party agreement to get through. And I want to say we haven't actually lost a sale, especially of a tenanted investment through this patch due to this reason. We haven't, valuation's a different thing, but on this particular topic, it's there's been a way around it.
Excellent. All right. Thanks, Ash. There's a question here about whether or not an employee is estimated eligible for JobKeeper, whether they need to return it or how they can return the JobKeeper payment if it's actually less and you're not affected enough by it. Our resident JobKeeper accountant expert isn't on this webinar. He has been on the previous ones. So Bill, we can get that question over to him and he might be able to give you some guidance in relation to that, because I don't know about you guys, but I don't know the answer to that one.
No, I would have thought that there's probably no actual mechanism to do it right now, but there would be in the future. So if you're concerned about that, I would put the money into another account and talk to, we can send you Roger's details or your accountant about that.
Excellent. All right. Question here. Once a business is open and trading again, but has received a benefit of reduced rental, can a landlord insist the rental returns back to the full rate? Some landlords are popping past their tenants just to see how they are trading. Oh, right. Popping past, doing a drive-by to see how they're trading. So, if it comes back again and everything's rosy, can the landlord insist on back to the old days?
It comes down to the agreement that they put in place. And so it becomes very difficult to, if you do an agreement for the whole 6 months now, then you're bound by that for the 6 months. The landlords can't go and do that. Just because people are popping past and there's people in the premises doesn't mean that they're back trading to full capacity too. Let's just be honest about that for a second. There's a lot of people doing freebies, a lot of people doing cheaper payments and all the rest of that. So it doesn't necessarily follow that just because someone is their premises has lots of people in it that they're making lots of money. If an agreement's been done for the whole 6 months, you're bound by that 6 months. The alternative would be to only negotiate, say, a portion of it and then try and negotiate a portion of it later. That's going to be problematic because how many negotiations, how much back and forth do you go? I don't know whether you've seen that one, Ash, but I would have thought that once you do an agreement, you've done an agreement, and that's it. Yeah,
and there's the trying to find that happy medium of our situation changes by the day, the week, the month, but how many times do we all just settle on, all right, we're 3 month agreement, but let's reassess then, because it's fairly, it's onerous. We're all busy and trying to do our business, especially tenants, to have to take on this extra workload of running through this process every month, 2 months, 3 months is a tricky thing, but it's reasonable to expect that if everyone's situation improves, we don't need to be shackled to a deal from 5 months ago. So.
Yep. Awesome. All right. Another question here. Is it mandatory to negotiate a greater than 25% waiver and 25% deferral?
Do you want to handle that one, Ash?
I think my understanding is that the JobKeeper qualifies at 30% reduction, so it could just be 15 and 15 if the numbers are showing that, depending on the actual impact on the business, that the numbers, the split has to reflect the true impact on the business. Am I understanding that right?
Yep.
Yeah, I think that's right. I think that, the percentage of the waiver and the deferral, Matt, are determined by the downturn in the revenue for the business. So if the business is only down 30%, then it's 15-15. If it's down 100, then it's 50-50. So it's not based on the rent. It's based on the reduction in turnover. I think it's the important distinction. Josephine, does that answer your question? Do you want to answer the next one, Craig?
Yeah, well, Josephine's actually got another question here, so I'll go to that one. If a tenant wants to cash in their 3-month bond to pay the negotiated discounted rent, can this be done if both landlord and tenant agree?
Short answer is yes, if they agree. The question I'd have though is, if you're a landlord, is there going to be a replacement security put in place? And from my reading of the rules, you wouldn't be able to require that replacement security until after the 1st of October. So be very, very careful with that, because it could be seen as unrealistic, and you'd also want the tenant to acknowledge why that they want that to occur, and that they acknowledge that they might have to pay some money back later. Otherwise, they might feel that they've been unfairly treated in the future.
Yeah, absolutely. Josephine just said that the tenant's actually offered.
Yeah, and that can be fine, but just think about the other side to that. So how is that repaid? Is it ever repaid? And if it is, making sure that's reasonable and making sure that's after the 1st of October, that would be repaid.
Yeah, absolutely. All right, just a question regarding lack of information from a tenant. So the tenants of motels come up with excuses to not provide figures, even though we've reduced rent by 50%. Do we have any recourse to claim the reduction due to the tenant's non-compliance?
My thought is yes, that now that the rules have come out, that you can require the tenant to provide that information. If you have already documented it, though, it could be problematic. However, that if you have reduced it and that's on a handshake and they haven't provided that information, then I think a carefully worded letter pointing out their obligations under the regulations could require them to provide that. Ash, have you encountered that one yet?
Not yet, no. But it does trigger that in good faith conversation that the commission is talking about there, and that's point one that they've made is tenant doesn't submit the information. So that's first cab off the rank on what not to do in that case. Yeah,
absolutely. There's this other question about agreements. This one's about prior to the code of conduct. So if the lessor and the lessee's made an agreement prior to that, both parties have signed it. Is there anything that now needs to be renegotiated to comply with the actual code of conduct that's been released?
So the first step would be to make sure that what's been agreed complies with the code. And as a bare minimum, if it has been, then there probably wouldn't be any need to renegotiate. However, there is also we haven't really talked about this, but after an agreement's done, if the tenant can show further decline in rent, in income, they can ask for a further decline in the rent that they have to pay, but they can't defer the rent. They can only get that portion put onto their lease at the end of the day. So the short answer is, if the deed complies with the code, then there's no need to review it, to change it. But if it doesn't, then either party could request that it be amended based on what the code says.
All right. This last question here: can a tenant who is affiliated / connected with a parent company claim to be eligible under the code? Their turnover is less than 50 million, but the parent company group is over 50 million. So
this is a question that's really going to require us to get some more information. we need to find out if there's different rules about groups and franchises and licenses and all the rest of that. So happy to take that one offline because I don't think we can answer that question just based on that question. We need to find out a bit more about that company and a few more details. So feel free to contact us about that one.
Excellent. That's great. That's all the questions that have come up on the chat. Oh, no, hold on a second. Is there a checklist available for navigating the process of qualifying tenants?
We've put some stuff together for that, and so have you, Ash, haven't you?
Yeah, but yours is accurate as of today, which is good. So yeah.
we'll provide all that in the email that we send out after this. So we've put together some checklists and all that information for people to use. So yeah, absolutely.
Excellent. Now, I think Ash, you were going to talk about the market before we got onto the questions.
It's probably just a quick,
hard and fast.
Yeah, it's probably just a quick sanity check from the coalface of, we've got 400 properties under management. We've got 15 agents out there in the field doing the thing, talking to people. And interesting, early on in the piece, we had 140 requests come in from our tenants for rent assistance. So that was during March and April. We only had one in May. So that whole calm is contagious thing is actually in play. We've seen a de-escalation of the fear and the frantic in the communication, and the vast majority. And another interesting thing is, of the 140 requests that we had come in, 50%, just over 50% weren't actually eligible for JobKeeper when the dust settled. So, and a lot of that was early kind of knee-jerk requests that came in, but once they got comfortable with knowing how their specific business was going to be impacted, then they basically withdrew the claim. But in general, the commentary between the behaviour between owners and tenants has been fantastic. So it's very rare cases on either side where it's getting into getting nasty or getting delayed or slow. Most has been really really smooth in the operation. We all understand that it doesn't have to be to the letter with this as well. That factoring in what's the true impact to the business, how is getting that business through this time going to benefit the owners as well is just a logical conversation to have. So it's been, I just wanted to share that side of it, of what we're actually seeing there.
Thanks, Ash. There was one last question. Josephine just asked the question: if they are not eligible for JobKeeper, are they still eligible for rent reduction? No. So being eligible for JobKeeper is one of the requirements of the code. Bearing in mind too that the way that the JobKeeper legislation has been written, you can be eligible at any time up until the end of September for JobKeeper. So just because they're not eligible now on the 1st of June when we're doing this recording, doesn't mean that on the 1st of July that they might not be eligible for JobKeeper. The legislation was deliberately kept quite fluid in that regard. So we just need to be careful on that one too. All right. Any other questions? Nathan just asked a question. Would that then exclude an entity which doesn't have any staff? No. So actually, I know you, Nathan, and I've actually looked at that question specifically, and that has not been. It actually talks about a group. So that's actually a good question. If you've got a trading entity that has been affected, and the actual entity that leases is an affiliated entity, then they're included in the affected leases as well. So you don't need to worry about that. Ash, Craig's asked a question: how is the market entertaining the rent-free incentives when commencing a new lease?
I'll jump in on that. It's been quite industry specific. So the industrial market hasn't really been impacted, and the actual activity level in the industrial is stronger than, it's back to actually outperforming February at the moment, because quite a few have got new contracts in place, or they understand, they've had a bump in online, distribution and critical infrastructure with gearing up for some of the projects that are going to be coming online and getting fast tracked. There's been a lot of musical chairs in that industrial front. Hasn't been a great need for additional incentives in those cases. There have been actually some really encouraging signs out of the retail and office markets in the last month. Office being primarily driven by allied health, but retail's been across the board. Convenience retail has been strong the whole way through. So there's been some input from owners in terms of fit out incentives, but that's tying in with it's worked in well with the June 30 instant asset write-off in a couple of fronts. So even like a supermarket with fridge installs, that kind of thing, it's worked out for some businesses that were on the fence of expanding or doing refurbs. They've jumped at the chance to during the quiet time to make that move. So there's been a slight increase in incentives, but it's actually been one of the standouts for me across across all the deals I'm seeing come in, is the lack of additional incentive that I would have expected to see through this to try and actually stimulate leases being done.
Cool. All right, there's just one final question here. What if the tenant has stopped paying rent and is not communicating at all, despite multiple requests for turnover figures?
So if they're entitled to JobKeeper, and so they're an affected lease, then that would be a dispute that you would have to go to the commission about. If they're not entitled to JobKeeper, because I know, Justin, you asked that question about if they're not eligible for JobKeeper, then it's just a normal breach of lease, and none of these regulations apply, and you would deal with it in the normal course. You would issue them a breach and deal with it as per normal. If they then say, oh, we're affected, then you'd have to stop, but that might be a way to smoke them out, as it were, if they're not responding, is to breach them and see what they say. There was a lot of early thoughts that this would apply to all leases, and as Ash said, that they got a lot of requests. I know a lot of agents got a lot of requests from tenants who weren't eligible for it, so people thought it would apply to them, and it doesn't. So that might be what you need to do there. I received a question from someone, Craig, about long service leave and JobKeeper. Short answer is I don't know, but Tita had the answer about JobKeeper stuff. I'll pass on your request and email address to our resident expert who's not on the call today, Roger, and I'll ask him to get back to you about that one.
All right. A couple other questions came in. Does eligibility for JobKeeper mean the tenant automatically qualifies for rental assistance?
So long as they're under $50 million in turnover and they've got a lease that was in the 28th of May, then yes, they automatically comply, and they can apply for rental assistance.
There's just an asterisk with that question as well, even if their reduced income is in excess of previous quarters.
Yes, so that's an interesting one, actually, that we haven't had to deal with as yet. But yeah, because people can be eligible for JobKeeper for potential future loss under some of the rules. So if they're not actually having the alternative JobKeeper test, then they're not really entitled to any rent reduction. They can still apply for it, but yeah, what's their reduction? Would be pretty hard for them to actually receive anything in that situation.
Yeah, absolutely. All right, and just
I did have one of our owners describe the JobKeeper test as an intelligence test, not a means test. So which seems fitting some of the businesses you've seen that can fit through the loophole. Yeah, it fits.
Yeah, absolutely. Speaking of intelligent questions, does the tenant's balance sheet have any bearing on negotiating in good faith? I.e., if they have a strong balance sheet, would that weaken their negotiating position?
All right, so this is when I call Nathan out for not being on the call at the beginning. I have to address this, and because you're a friend, Nathan, I can do that. However, so that's one of the. No, it's all good. You said sorry. No, I'm just playing with it. So one of the things that's expressly excluded by the commissioner is asking for things like the the balance sheet. So landlords can't ask for balance sheets. They can't ask for audited financials. They can't ask for bank statements. They can't ask for a bunch of other information. So balance sheet has no bearing on it. It's just your current management financials that you have to provide.
So as a tenant, you should be only providing the minimum.
Yes, that's right. Yeah.
In compliance with that. I think there's no other questions coming in at the moment. Hold on, Josephine. Can they ask for the BAS 2019 quarter and 2020 quarter?
So my answer is yes, because that's probably what their JobKeeper was based on. That was the first test for JobKeeper, was providing the March BAS as against the March BAS, or 19 March BAS against 20 March BAS. So that they could quite properly ask for that.
Yeah, and the BAS lodgement is one of the documents that can be asked for.
That's right.
Yeah. All right. There's no other questions, but just put up a slide, Jeremy, perhaps with your details and Ash's details.
Yeah.
There you go. There's some pictures of you. So as we said throughout today's webinar, there are some resources that we'll share after this. The video will also be available of the webinar. So you can review that. If you missed the beginning, perhaps you can jump on and watch the beginning. We obviously thank everyone for joining us today. And then we also thank Ashley and Jeremy for coming on and sharing all of their information that they have on this topic. As we said at the beginning, it's kind of the final piece in the puzzle for all of this COVID stuff that's been going on for businesses. And it's going to continue obviously with the leasing and just sort of getting all this sorted out. But now we've got some clarity about exactly what it is that we need to be doing. So thank you, Jeremy and Ash, for joining us and answering all the questions. Listeners and viewers, if you've got any other questions, the details are there for Jeremy and Ash to get in touch with them. For anyone that we said we'd get back to or pass on to Roger, we'll get onto that as well. So that's Roger Hawley from Hawley Accounting, our resident JobKeeper expert. Gents, anything else you want to share before we sign off for today?
No, otherwise just to say thank you to everyone for taking the time to do this. There's not a, we haven't been able to be certain in some areas, but we're here to help, and there's a lot of specific questions that we'll be able to help people with once we have a look at their situations.
Yep, same. Keep your questions coming, and we're learning by the day as well with it, but it's going well.
Great. All right. Thanks, everyone. See you next time.